Joe, I believe. Joe, I believe if you're on, I know this is something that I believe particularly you wanted to see discussed, and I'm happy to kind of, while I'm the chair of the work group, just open this up sort of for discussion at this point. And if there's anything that you'd like to lead off with, Joe, I'm happy to address it. I appreciate what Jason sent around to all of us to look at with respect to the code provisions, but I do think it might make sense to kind of open it up. Joe, if there's something directly that you want to talk about at this point, or we can kind of open it up to a general discussion.
Well, I mean, I think that I don't think that we have laid out a way that we want to roll on how we want to discuss impairment at this committee meeting. I think there are people that I can find, like from other states or jurisdictions, that have have basically what we would perceive, or I perceive, as experts in how it's defined, with people like, especially from the police background. I don't know whether Jason was able to find, is that what you said, that you had sent us a format or a form of something that?
So in the email I sent previously, I included the relevant sections of the Medical Cannabis Act that may have to do with impairment. And also in the chat, I included State Code 17C-5-2, which has to do with driving under the influence. And in that code, impaired state means, and there are several definitions for different substances, but I believe the one that would apply here is B. It says impaired state means a person is under the influence of any controlled substance. Or C says that impaired state means is under the influence of any drug or inhalant substance. So it's a very broad definition for sure.
Jason, does the Act identify medical marijuana as a controlled substance?
I believe it does not.
No, I think that's some of the issue, and that's kind of what we're looking at is whether there's recommendations that ought to be made about how to address it. I know we've heard from state police representatives previously that, and I know from experience as an attorney, having worked in areas including impairment areas, that it's a little bit of a gray area as to how you get to someone under a certain level of influence for cannabis, because some states have enacted different nanogram levels. The issue is whether or not those are active in a bloodstream, and that becomes really difficult medically. Alcohol metabolizes a lot faster, and that was part of, in the 70s and early 1980s when they were putting in the standards for levels of alcohol concentration in the blood. One of the issues was that, you'd have to be able to measure it quickly, which is what they finally came up with the etoxalyzer for. And you can measure those because they do metabolize out very quickly. With cannabis, those things build in a person's bloodstream. And so it becomes difficult to just say, hey, there's going to be this many nanograms of THC or in someone's blood, because if they're a active user and they're a medical cannabis patient and they use it regularly, they may not necessarily be under the effects of it, but it doesn't metabolize out very quickly. That's why you see, even urine drug screens that can show that someone used cannabis within a month or longer. And so that's one of the issues. We really kind of need to think about how we want to go about making recommendations, if any, to the legislature about what they ought to do to try to put something in place. And that's something that, I think law enforcement would be good, but we've had some law enforcement speakers in the past that, again, in the state really don't have a uniform guideline. So it may make sense for us to look outside the state to, states that have had this happen for a long time to see how they're addressing it, and whether there's some national standards on that. I mean, there's, the National Highway Safety Institute puts out standards all the time for DUIs. I'm sure we could probably get a speaker from there. Maybe we get a speaker from Colorado or California or somewhere that's had this issue for a lot longer, that's enacted things that involve it. And Rusty, I don't know if you have thoughts on that too. I mean, I think it'd be important for us to hear from everybody on this as to maybe what types of people we ought to be listening to, so that we're going to put together a recommendation for the full board and ultimately the legislature. We're looking at people that have invented this process already, not just, starting from scratch.
Well, yeah, and also, if we're going to talk to law enforcement, of course, I think we should bring law enforcement in from. I would recommend California. Like I say, they've been doing it since '96. They've got a lot of research to go off of. But I also think that part of this conversation, we're going to have to talk with patients. For me, I was lucky when I left chemotherapy treatments, I had a ride home from the hospital. But if I would not have had that support system and had I had to drive myself, once those nausea meds wear off, I was so dizzy and the vertigo would get so bad that I was not safe behind the wheel of a car. If I had to do that. After using cannabis, the vertigo and the nausea would go away immediately. And I could argue the fact that I was probably more impaired before cannabis. So I think that there's some nuances to this discussion that we're going to have to take into account when you're talking about impairment, because it's just like, for instance, there are coal miners who are going into the mines every day and working, that's a hard job. A lot of them are on, pain medication and it's long-term pain management regimens that they're operating under. And are they considered impaired? If you're taking a medicine and that medicine is helping you function and helping you get, through your day more effectively, I would argue that that's not, that's not really impaired. So I think that there's definite nuances to this conversation. So if we're going to bring in law enforcement, we also should bring in physicians. I think from states that have been, seeing patients for years as part of this discussion, and bring all the voices to the table. But I don't think it's something that we are in any position to be talking about making recommendations right now on. I think there's a lot of information we need to bring in.
Jason, has the office looked at, and it may just not be something that, that the Office of Medical Cannabis has looked into at this point, but have you all looked into other states as to whether they've enacted things, and any thought from the office as to whether there's any recommendations on that?
In regards to impairment specifically?
Yes, sir.
No, we have not.
So, we have talked, with some folks, and we probably could get someone or one or more folks from out west, California or Colorado, from law enforcement that could speak to it. We may want to do it, that Rusty finds some folks and we find some folks, and we have a limited time frame like we did on home grow, and then we have question answer period. Just in fairness, we probably need to hear from victims, to some degree. There are people who may have have suffered damage, or family members killed in a car wreck, with somebody who's impaired on cannabis or Delta 8, or that there's something just recently happened in Kanawha County that where a person had Delta 8 and Delta 9 in their system, and said that they hit on it an hour before they drove and had a head-on collision with somebody. So I think it's definitely something that we need to address, and try and come up with something that is going to work, so that the state police and different folks and even workplaces can have some guidelines.
Well, and it makes sense, I think, to have other. Oh, go ahead, Joe. Oh, sorry, I thought somebody was still speaking. It would make sense, I think, to have all the voices at the table, but I still think looking at places that have had this debate previously and enacted things, we may find things we like and things we don't like from certain states, and we could try to model after it because, to your point, I mean, certainly there are horror stories that can be told about, people that have been victims of car crashes, or people are under the influence of a whole host of things, be it prescription medication, be it cannabis, be it alcohol. The situation you're talking about in Kanawha County with the Delta 8, I mean, that would be outside really the scope of even the Cannabis Act, because we're talking about something that's not medical cannabis. I mean, it's a product that's essentially sold over the counter. And so, it's not, I mean, it may not be something necessarily that we can address with this board in terms of the Delta 8, but certainly with cannabis, that's something we need to be looking at. There's also, and some of this is anecdotal, but I know from the experience in the legal world that there are people that have been accused of being under the influence of cannabis right now, that it's just off of an officer's observations. I think we heard some of that from the state police representative that spoke to us previously, that, there's no guidelines to protect people that may be innocent that are accused of this too. I mean, to Rusty's point, if you've got people that are using this properly, that are patients that, use it at home when they need to, and a day or two later, maybe they're operating a vehicle, they may not be under the influence in any way, but they may still have something in a blood draw that would make it look like they are. And so, there's got to be some medium to that where we don't have people falsely accused of crimes either. And so, or falsely be in a position where they have some kind of legal negligence, or their insurance carrier does. So, I think there's a lot of people that would want to see standards put in place if it's possible. And there's other states that have looked at this for a long time. So, I mean, I would think we need people from, we really probably need, everyone to identify some potential speakers and schedule another meeting where we could have those speakers lined up and really have more of a healthy debate. I kind of view tonight as more of a, almost a strategy meeting amongst this work group to decide, how are we going to move forward with the impairment issue. And my recommendation would be that we all look at potential speakers. Maybe we could circulate those to Jason within the next, I know we have the holidays coming up, but maybe, by mid-January, if we could circulate some potential names, and then we can schedule another work group meeting for, when's the next board meeting, Jason, the full board?
I want to say January 5th. It's the Thursday after the
first Thursday in January.
So maybe, we could look at somewhere in early February to have another work group meeting, and we could have some speakers lined up on this impairment issue. Rusty, what do you think about that?
Yeah, I like the idea of bringing in speakers, but I don't necessarily like the idea of turning it into a debate. It's like when you take a class on something, you go and you listen to the professor, the expert on the subject matter, and you take the information and you run with that information. I think that when we do this stuff and it's like, well, we're going to invite some people who are completely against it, and you go invite somebody that's completely supporting and we'll debate it. I don't think that's what we're here to do. I think we're here to provide, we're here to make decisions based on proper information. And when it turns into a debate, I just think it's theater to me. And, I just think there's a better way to go about it than that. When we were talking about home grow was an issue that could have benefited a lot of patients in arguably one of the most economically depressed states in the country. And we had to sit here and listen to experts, talk horror stories about all of this cartel violence and stuff that was pertaining to legal recreational cannabis states. The speakers acknowledged in their remarks, when I challenged them on it every single time, that they were not talking about medical cannabis programs. I asked questions directly, like, of all of these stories and these violent situations, how many of the perpetrators were card-carrying medical cannabis patients? Their answers were zero, but their opinion was still taken just as, it was taken as the gospel. And I think that that's nonsense. We need to bring people in here. I don't need to be the one inviting him. I don't think that Joe Deegan needs to be the one inviting the speakers in here. We need to find some people, that are willing to look at this through an objective lens and bring actual experts in to talk rather than, turn it into a debate. And that's just how I feel about it.
Jesse, getting back on topic now, how concerned are you that that's not being specifically named in the Impaired Drivers Act, that an energetic lawyer could argue that it doesn't apply?
Oh, cannabis itself,
Yeah,
I don't think that's much of a concern at all. I mean, the police agencies charge people with driving under the influence of cannabis routinely. They have for many years. I've been involved in cases involving that for years and years. And so the broad section that was read earlier about the fact that you can charge somebody for being under the influence of drugs is broad enough. I mean, I've seen people charged with DUI when it's their own prescriptions, and they've used them in a way that the law enforcement officer believes they were not able to effectively operate a motor vehicle, and it becomes very subjective, which is sort of I think that's part of what we need to look at is there a way to put some kind of objective criteria in place for law enforcement? Because right now, alcohol gets measured on the 0.08 scale, and there's an intoximeter, and you can rely on that, or a blood draw. With cannabis, it really becomes the police officer's personal observations as to whether or not they think the person is under the influence. There's no set cutoff, but it happens routinely with cannabis and a whole host of other drugs, even though there's nothing specific in the motor vehicle statutes about the level of intoxication. It really becomes a default of, if the officer's personal observations are such that they believe the person is under the influence and they have evidence that they're under the influence, then it's just their observations as to whether or not they're not able to safely operate a vehicle. It becomes a judge or a jury's decision on the criminal side, and it becomes a judge's decision on their driver's license as to whether or not they're beyond an appropriate level. So it's really something that it's a little bit of the Wild West in terms of where people are at on this without having some kind of standards in place. But I don't think it's something that you have to worry about that law enforcement's not charging folks with now. I think, in fact, we heard from, and I don't know, how long ago that was. We heard from a state trooper that's charged people with this, and it happens probably every day.
thank you. That was very helpful.
So I'd like to jump in with a couple questions of Joe or any other member, just to, like Jesse said, set some strategy moving forward. Because Section 5 of the Medical Cannabis Act does set a specific blood level of THC that's allowed, when you're operating a car, for example. That's what we keep using for an example. If the work group does decide to move forwards with a potential recommendation, do you feel like it's going to be in addition to that blood level, sort of an and or, if the person shows signs of impairment, and then define it out from there? Is that where we're going potentially?
I would think, and I mean, we could all jump into this debate, but I use the word debate. I understand Rusty's point, but it's really more of a discussion than a debate. But we can all jump into this. It seems to me, we need to know if those levels are appropriate, and then whether or not the motor vehicle statutes should be modified to either mirror that or maybe adjust it. I mean, I think that's part of our role, is to say, hey, is the existing law good? Do we need other things in place elsewhere in the code? Are those levels correct? And that's something that I think we really, we need to hear, maybe not so much, from anecdotal stories of people that were injured or people that were, concerned about being falsely accused or something like that. I think we need really the law enforcement or the regulators that have put this stuff in place in other states, and then seen the overall problems, not, on a micro level problems on an individual's case, but with the entire system of how this works and how it operates in the justice system in these individual states that have been doing it for a long time. And I'm not saying limit it to California or Colorado. Those are just easy ones to look at because they've been doing this for so long. But I think we need people that have looked at this and had it in place for a very long time and have their motor vehicle statutes already dealing with this. And then maybe we suggest that they mirror that language in our motor vehicle statutes. Maybe we look at tweaking that language.
Okay, so it sounds like perhaps 5-10-1 that sets that 3 nanogram limit may also become part of this discussion.
I think so.
Okay. My second question is, does the work group feel like it wants to hash out specific language in the potential recommendation, or do you simply want to say to the legislature, and again, we're speculating here, do you simply want to say that you recommend that impairment language is added to the act, or you recommend that the nanogram level be evaluated? So more general or more specific?
I think that's going to depend on, what if there's a consensus among the work group, really. And then, and I think it's premature to even say, because, again, I think we really need to hear from people that have been in the throes of this a lot longer than we have. And maybe, we may hear from, a representative from the Highway Patrol in California who's been doing this for a long time, who says, oh my gosh, no, 3 nanograms is wrong, and here's why. You need this language instead. I mean, and it may be that, maybe we reach out to the prosecuting attorneys institutes in some of these states that have looked at this, and they're actually in the courtrooms dealing with this. I mean, that may be the type of place that we need to really go, because, the legislature writes these things, and then what happens is you get a law enforcement officer that tries to enforce it, and ultimately you're in court on the criminal side with prosecutors and defense lawyers and a judge. And that's, I mean, I kind of think for something like this, that's really where we might do better, and we might find more impartiality that way too. I mean, to Rusty and Joe's point, I mean, we need speakers that really understand why it is that we're going to be recommending things. And so I think it's premature to say whether we want to make a general recommendation to the legislature or a specific fix. I mean, we may hear from, a representative of the district attorneys in California who says, look, we've been doing this for a long time. Here's how we started. This is what we changed. And maybe we all think that that's great. We make a uniform recommendation. It may be that we look at that and, like we've had with issues in the past, maybe we're all over the place, and maybe we don't have uniformity, in which case maybe we could agree to make a general recommendation that the legislature study this. I mean, ultimately it's up to the legislature. It's not going to be up to us. So it's just a question of how we phrase, if we make a recommendation, how we phrase it.
Jason, I think if law enforcement and the prosecutorial side are okay with it as is, then it becomes a moot point.
Well, maybe we need to, maybe we should invite someone from the Prosecuting Attorneys Institute in West Virginia. But, I'll tell you, having dealt with it, they all know, most of the ones that I talk to, I mean, there's not a good standard for cannabis cases right now. And this is something that's going to get bigger and bigger as a problem because of the fact that there's, legalized medical cannabis at this point. And so we could certainly hear from them, but I just wonder whether there's enough experience with the legalization end of this now to say that it is a problem or not. But certainly I think it would be good to hear from, prosecutors here locally within West Virginia. But ultimately, I think if we could hear from people that have kind of, made the mistakes in the past and made the good decisions in the past, that may help us.
I feel like I need to make a comment too. It's like, Rusty, I don't see when we get different perspectives on things as that it's debate. It's, people have different points of view. A trial lawyer is going to look at this different than a prosecuting attorney is going to look at it. So you weigh both sides, and we may find somebody who is out there that we're all going to be able to agree with, but we may find even different law enforcement agencies that have different ways of looking at this. I don't see where that is a problem. I think it's how we handle ourselves when we have different points of view, that we're civil with each other, and not and basically just listen to what each side has to say, and ask questions, and then make a decision accordingly. I don't want to be X'd out of being able to make a recommendation to find somebody. I don't feel like I've been finding people who are totally impartial one way or the other. I think I've been looking for people who have a point of view that needs to be valued, or at least listened to. So, I don't want to be ruled out on this committee, or I'm going to be gone from the committee if I'm not going to be able to participate and being active on the committee because another person on the committee doesn't like who I bring to the table. I mean, it's just not appropriate.
That's not what I'm saying, man. And I don't, you and I've had these discussions more than a few times. Take it so personally. It's not a personal thing. I'm just saying, if we're looking for factual information.
If it's not personal, then don't put my name in it.
If you're looking for factual information, I'm just saying you should go to the people who are doing the research, who have access to the information, allow them to present the information, and then you can discuss it and debate it all you want. But bringing people in with their opinion and they sell it as fact, which has happened. It happened all the way through the home grow discussion. It's happened at pretty much every time we've brought someone in. That to me is not how we are going to make the best recommendations. I understand your point of view. That's cool. You have your point of view. I have my point of view.
Okay.
I'm saying take my point of view out. Take your point of view out. Let's bring in the experts who know what's going on because they're doing the work.
I'm not agreeing to have my point of view taken out.
So-
I don't feel like
I got
it.
So we have to maintain the ability.
Such thin skin.
We have to maintain the ability for content to come from the board members. Again, like I mentioned before, OMC doesn't want to be put in the position of providing all the content for these meetings, because we need to maintain the separation between OMC and the board. They're two different entities whose viewpoints may or may not align, now and in the future. So we're happy to, facilitate the meetings. We're happy to help with research, but the content, like speakers, really needs to come from the membership. However, the membership decides that is appropriate.
Yeah,
Hey, Jason, so if you don't mind, the 3 nanograms is a blood test.
Yes.
How is that performed and who does that?
That's a tough one. That's one of the unanswered questions. Where is that blood test going to be performed? I would say typically at a hospital. Whether that could happen in all situations is a whole nother ball of wax. And that's, I've heard from other states, the entire country is struggling with that. As Jesse's mentioned multiple times, there is no breathalyzer for this. And getting a blood test is not the easiest thing. Jesse, perhaps you have more to add to that.
You either have to have, the driver has to consent to it, or the officer can go get a warrant for a blood draw. And then they do typically take place at hospitals. And so you end up with, now you've got an officer that's got to figure out a way to get the person, especially if they're in a rural area, they've got to get them to a hospital that can perform it. You've got all those issues that are there. While the DUIs that you see involving, well, it would be with alcohol, and it is with alcohol. I've seen a lot of defenses and a lot of prosecutions with alcohol where it becomes a real issue because that stuff metabolizes so quickly. And then you get into experts talking about, well, what would the blood level have been at the time of the driving? With marijuana, with cannabis, it's very slow to metabolize. We've heard that from all the experts on the board, they've come in and talked before, but if you look at the research on it, the nanogram levels may stay elevated for a long time if you're a habitual user. So, if you're someone that's a medical cannabis patient and you're using this stuff on a regular basis, you may have nanogram levels in your blood that aren't necessarily showing an impairment level, which is part of the problem, but it can be time sensitive, but I don't think it's as time sensitive as what you see with alcohol, at least in my experience in the legal world when we've had experts testify on this stuff. But that gets back to, we need some people that have been down this road to kind of tell us, does the nanogram level make sense? Is there a better way to do it? I mean, I think, as Jason said, people across the country have struggled with this and are struggling with it. And that's why a lot of times you see it as personal observations of the officer. But that puts a heck of a lot of weight on an officer who already believes the person's under the influence, or they wouldn't have arrested. So it's, it's a difficult area to be in. Back to some of this back and forth, I hate that we've kind of got there with everybody, but I do see Jason's point. I mean, that, we're charged as a board to try to discuss these topics and decide if, consensus wise as a board, if we want to make various recommendations. And I think the board members are going to have to bring their own people in to talk. And I mean, we're just going to have to allot some time. And I would hope that each board member, if any of us make recommendations to bring a speaker, that we're looking for people that are impartial, particularly on this issue, because this isn't an issue that, you really need to have an agenda with. I mean, this is more of a highway safety issue. And I think law enforcement, prosecutors, maybe some, defense institutes that have dealt with this, and people from the, scientific or medical backgrounds. But we do need some people to give us some guidance on this as to whether that nanogram level makes sense and whether we ought to tweak the rest of the code with it or not.
That nanogram is in our state code. There is no
Yes.
federal code on that, obviously, since cannabis is illegal.
Plus, there's
So-
no federal code on driving. I mean, DUIs are state court charges, so it's not, you're not going to end up with a federal act on it anyway.
Okay, so I guess I wonder how even this section of state code is even relevant if nobody can go and test for 3 nanograms.
And just to clarify, Joe, there are a whole list of activities that are addressed here. It's not just operating a vehicle. It's things like working in a chemical plant and working with electricity. And
Right, but if
There's a-
nobody can go and test for 3 nanograms, that whole section is really irrelevant.
yeah, it's
Yeah.
a tough one.
And I don't mean that the wrong way. It's just the fact is, if nobody can actually perform the chemical analysis on the blood, then that section of code is strictly there for looks. It's not enforceable.
Well, unless you get, consent to a blood draw, or, in the DUI
But even if
context.
you can do a blood draw and nobody can run the analysis on the blood draw, then it's irrelevant to collect the blood.
Yeah, if they can't run it, but I mean, there are ways to run the nanogram levels. I think it's just a matter of whether or not you actually get somebody to consent to a draw, or, get a warrant for their blood.
Yeah, a hospital
just a-
lab should be able to do the test.
Yeah, the problem is that they don't, I mean, if you look at the literature around the country, the nanogram levels may not really mean much for somebody who's a cancer patient that uses this stuff regularly, because they're going to have an elevated nanogram level that's going to register anyway. I mean, we really do need a better test, but that's probably a national issue, which again gets me back to, I'd like to know how, a state that's been dealing with DUIs or heavy machinery issues, employment issues on this for 20 years has been dealing with.
Something else that may provide an interesting perspective, we could have perhaps our Office of Laboratory Services come on and actually talk about the test itself, how expensive it might be, what all's involved, how long it takes. Might be useful information.
Yeah, either to
We
speak
ought to
or
have
if they could
somebody
put
talk about
something.
it, Jason. Yep.
I'm sorry.
I think somebody should talk about that.
Yeah,
And
yeah,
whether it's available even. My staff don't think it's available.
we should definitely be able to provide a good perspective on that.
So, yeah, I think that we probably have some homework to do to try and find some impartial people who are out there that can give us some perspective on this, and try to come up with an agreement on who those folks are and then have another meeting in February. I don't know if we'll be able to pull all that together before February, but we could try.
Okay,
You know.
so just to recap the possible action items, OMC is going to do some research on laws of other states, perhaps look for a lab perspective. The members are going to look for speakers that may be able to address the issue. Does that sound right to everyone?
Yeah. Yes.
Anything anyone else wants to have us look at or have someone else speak about regarding impairment?
I think we're good.
Will you send those out as action items or something, Jason?
Yeah, I can do that. Jesse, is there anything else the work group wants to address tonight?
Not for me. Does anybody else have anything?
I'm curious as to when we're going to bring the reciprocity discussion back up in the mix. I know we were going to bring that, at least it was my understanding, we were going to bring it back to the work group. So I'm getting asked by patients pretty frequently, what's up with reciprocity. So I thought I'd throw that back out in the mix.
What about setting, that maybe we'll do one meeting on impairment and another meeting on reciprocity, and this could be the next 2 meetings. And, if we feel like we're all in a position where we can do the impairment one in February, that's fine. I'm open to a discussion if everybody wants to have some more time to deal with getting the impairment people lined up. If we want to discuss reciprocity at the next meeting, we certainly can. What's everybody else's thoughts on that?
I'm good with that.
I thought we had another issue that we wanted to talk about. I think it was
you had brought up effects on healthcare facilities.
I mean, that was something that we all talked about before, that how is all this being interpreted at hospitals, FQHCs, comprehensive mental health centers, got all of that. That was the next item from my notes that we had on the list, for discussion. Impairment was first, and then where do we go with health facilities?
That's going to be a particularly tough area because these facilities are all under different guidelines. I can tell you what WVUH did, but I don't think as a board we can recommend statewide that every hospital do this one particular way. Some areas may be more comfortable with it than others, and I feel it should be left up to the individual institution.
Jumping back to reciprocity, kind of echoing Rusty, I can tell you that is a huge issue, as far as public interest right now, as more and more states surrounding us come online with both medical and recreational cannabis. And, especially right now with the executive order in Kentucky, it's a pressing issue. But, it's totally up to the work group to set its own agenda.
That'd be the only thought I have is, with the legislative session starting and all these states around us with what's going on, does it make sense to try to address reciprocity sooner than, it seems to me the hospital issue is certainly important, and I understand we've talked about it in the past, but I'm not sure. It seems like we may be having a more generalized discussion on that than whether we're really making a specific recommendation right now. And with the session starting, it may make sense to move reciprocity up on the schedule. Does anybody have an issue with that?
And again, from an office perspective, our hands are really tied regarding reciprocity because of this very specific slice of eligibility built into the statute. So, until that's evaluated and may or may not change. There's really not a whole lot that can be done from our end.
Well, what if we lined out the next, 3 work group meetings? And I mean, if we want to combine them, we can, but I know sometimes we get very long on these things. I mean, this has been long and we're just talking about, planning right now. I mean, what if we met in February to continue the impairment discussion? We set a meeting in March to talk about reciprocity. And then set a meeting a month later in April, and we could discuss the hospital issue.
That's okay with me.
Part of me feels like we should switch and do, I think crossover day, I'm not 100% sure, but I think crossover day is February 15th. So any legislation, if it's going to be moving, it's got to be moving by then. It may make sense to have the reciprocity discussion before, crossover day. So if there is consensus, if we do decide that, reciprocity is we want to make recommendations, pertaining to reciprocity, they can act on it during legislative session. Because I think, determining impairment and figuring out all of the intricacies with the hospital networks, that those are going to be pretty heavy lifts. I don't think.
Well, Rusty, because of the structure of the board, unless the membership wanted to alter the meeting dates for the main meeting, the next main meeting wouldn't be until March.
Right. Yeah, that makes sense too. So, well, yeah,
Although,
back
it still could be helpful that if the work group is met, during the session prior to, I mean, it may not matter for the crossover day, but it may help generally if there's something, if the legislature is looking at something, maybe we can do some of those discussion. Maybe that would help with their process out there, even if we're making a specific. I'm fine to back up and, if we want to set another work group meeting in late January and then do February and March, fine by me. But that we're not going to make any recommendations that are going to get there before crossover day.
Right. Gotcha. Yeah, I didn't take into account that, the full board wouldn't be meeting until after session's over anyway. So that's my bad.
All right. So again, just so the office can be clear to facilitate this, we're talking about 3 meetings, each on separate topics. Do you want reciprocity to be first, or do you want impairment to be first?
My internet froze for a second, so I may have missed that.
I was just discussion of the.
We've been talking about impairment as the next issue, and we just set something that we're supposed to be gathering for the next meeting.
Jesse, my question was, which do you want to be first, impairment or reciprocity?
I'll go for impairment.
Dr. Baglienti says impairment.
I do. That was Joe that answered before.
Oh,
Okay.
Sorry.
It sounds like we got a consensus for impairment for the next meeting. So let's do impairment for our next work group meeting, and then reciprocity to meeting after that, and then we'll talk about healthcare,
All right.
health hospitals.
Sounds good.
We will get that scheduled.
Our task is to find some, hopefully, impartial speakers that can, give us some feedback on impairment that has some real substantive information.
So Jesse, if there's no further topics you guys wish to discuss, I'd recommend you take public comment if there is any.
Yeah, I mean, obviously we haven't, dealt with a lot of substantive issues tonight. It's really more about, planning as to how we're moving forward. But to the extent that there's public on that would like to speak, we are certainly here and happy to hear the comment.
All right. So for any members of the public that wish to comment, please put your name in the chat and we'll call on you one by one. Jesse, are you good with the typical 90 seconds?
Yes.
Okay. So please put your name in the chat, and you'll have 90 seconds to speak, and the board will hear your public comment. Anyone that wishes to comment, please put your name in the chat. All right. First up, we have Kevin. Kevin, whenever you're ready.
Hey, good evening, gentlemen. I just want to thank you for your time. Something to help you guys out. Governor Gavin Newsom in September passed signed a couple cannabis acts, 2188. And one of the things that they do to screen for cannabis is an oral swab, which will detect actual THC levels. And another thing they added was medical cannabis patients to be under a protected class. So I say if we're going to do some, testing of THC levels and things like that, I think the medical patients need to be protected on that end too. And another thing, just got a quick question about reciprocity is, what is the negative impact if West Virginia accepts any medical cannabis card from any state with an active medical cannabis program? Why can't we just do that? And what would be the negative impacts of why you would not vote for that? Thank you.
Well, I can speak to that question specifically. Reciprocity is specific in the act. It only applies to terminally ill cancer patients. So we would not be able to open up reciprocity to the larger group that may exist in that state. Again, it's a very small slice of the patient population. We actually just ran some numbers on that this morning, and out of almost 16,500 cards that have been issued, there are 11 terminally ill cancer patients in our state. So assuming the numbers would be similar across all states, again, it's going to be a very, very small slice of people that would qualify based on our current code. All right, next up we have Dr. Husted.
Thanks for taking my call. I was going to originally say something else, but then Kevin brought up the idea of giving complete immunity against impairment to anybody who has a medical card. I definitely see that as a dangerous thing road to go down, because, for instance, if I have a patient that I prescribe, a medicine that could possibly be altering, which cannabis is an intoxicant, depending on how much you use. If someone were to overuse the medical product, to the point that they're impaired and they get in the car and say, kill somebody driving, the idea that just simply having the medical card gives you, free reign to do whatever you want seems kind of ludicrous. There does have to be a level of, whether we see a blood level or someone determine, hey, this person's impaired, because clearly we are seeing, fatal car accidents, whether it's in our state or other states have legalized it recreationally or medically. So the idea of giving somebody kind of a get out of jail free card or immunity to prosecution seems kind of absurd, because there's nothing else in medicine where you have that. If someone misuses their medicine and causes a car accident, just the fact that I've prescribed someone medicine doesn't mean that they're immune to prosecution. So I don't think we should treat cannabis any differently. It'd be similar if some doctor gave someone a card to drink alcohol and then someone got a DUI and killed somebody. I don't think they would get away with the DUI just based on that. So
Doctor,
I would just,
your time is elapsed.
No, but I just would say take that into consideration. Thank you, guys.
Thank you. Next up, we have Donna Massey. Whenever you're ready, Donna. Donna Massey, are you there? It looks like you're muted, Donna.
Sorry, new at this.
Okay, you're good. Go ahead.
I haven't been in the medical cannabis industry very long, but I just want to say it is helping people. and I appreciate all the work y'all are doing. Thank you.
Thank you. All right. Is there any other member of the public that wishes to comment? If you do, please put your name in the chat. All right, Jesse, I believe that's it for public comment.
Okay. Well, with that, I guess that's that sort of concludes our meeting. Does anybody have anything else? Is there a motion to adjourn?
So moved.
Moved.
Okay.
And Merry Christmas.
You too.
All right. Thanks, everybody.